So Jane's back. So she said she's going to have to spoken to. She said she'll update me.
No, picked up her email.
So she will update me, and they're probably going to apply for permission to get the first 15 minutes.
They don't have
No, it's flashing. It's sort of orange. It's amber. Almost there. Oh, yeah. Alright, okay. Yeah, it's it's gone.
Oh, I said it's on now.
Is it? Oh, it's, yeah. Let's just check with John. Well, apologies to all those who were hoping to watch online for the interruption, but I gather it's up and running now, so that's good.
I should say that I missed the end of the question. You had an example.
I think the example I was giving was one where the party that is which is the debtor under the loan, so, is not able to gain any sort of advantage for itself, so it can't use it for any form of relief at all, then pays the money over to SEMA, which to Speedy One, which enables Speedy One to use up its trap losses against the interest. In that situation, surely there isn't any tax advantage to Speedy One.
Well, I think there the facts would allow the first to find that the purpose of paying the interest was to fund Speedy One. And
what you would call the tax advantage would be merely incidental to that purpose.
Yes, yes. So in all these cases, the examples or the answers usually in the example.
Yeah,
the very interesting thing about SEMA is the comparison with Claimant Benson. Both cases where the entity only made a profit because of the tax treatment, they would have both made a loss after tax.
Yes.
But for the tax treatment, in one, there is it's a main object or purpose test, the 703. In the other, there isn't, and it's because of the specific facts of the case.
Yeah.
And that was a point that really I just wanted to draw out from SEMA and the way that Mr. Gardner had put the case, because he says, echoing language that my learned friend uses in his skeleton, particular. At the bottom of page 115, he says, he makes his point about exemption and conceptually where it applies, and says, and of course the point about an exemption is that, Parliament's decided to give it to charitable trustees, pensions, and so on. And he says, for these reasons, the section included reference to relief from repayments, but not to exemptions. And it would be an abuse of language to describe the receipt of income which Parliament have provided should be exempt as a tax advantage. And that's a sort of echoing also the idea that there has to be avoidance for there to be a tax advantage at all, just as a bare matter of 1139. And of course that argument doesn't succeed, and it's an argument that's repeated all the way up through the courts. The exemption does make you better off vis-a-vis the revenue, because you don't have to pay tax on your income, and it doesn't matter that no other class of person like you would have had to have paid tax on the income. That's in the nature of an exemption. And calling things an abuse of language, or asking is it avoidance or not, is not the statutory test. The relief from tax is much simpler than that, and that's what the Court of Appeal is saying. There is a provision for avoidance, and cases like Parker dealt with that, but it's only one little bit of 1139 where you look for the avoidance of a charge to tax. And in particular, those words in, I think is it C, reduction in an assessment or charge, are really just very functional and neutral. But obviously, then when you step back and say, I'm only asking this because we're looking at 442, do I have a purpose of intending to secure that? Maybe not, and that's the difference between Seymour and Climate Benson.
There's another way of putting that point to say that the protection, very necessary one, for the taxpayer lies really in the purpose test, rather than in the question of tax advantage, which is intended probably to be, one would hope, to be a simple question to be answered without undue complication of any kind.
Absolutely, and in different anti-avoidance tests, so 703 as well as this, could reply any tax could be an issue.
Yes. And as I understand it, it's common ground that the test, as it appears in the loan relationship legislation, was expressly based on and effectively taken from Section 703.
Yes, and that's common ground, and I think it's now become, it's been common ground so long and assumed that I think
I dare say
taken as right.
Well, the wording is
the same.
identical.
The wording is so close, it's pretty much inevitable inference anyway, and so that's why everyone is quite content to look at the cases on 703 and so forth in the present context. One can have problems when a technical set of provisions from one tax context is transplanted by Parliament into another, and it's always a question of how much of the original baggage gets taken over.
That's right.
Where the purpose of the new legislation may be actually rather different from that of the original legislation. But
it's also, a lot of the argument in SEMA was to do with the fact that the corporation tax rules had changed, including for ACT. And one of Mr. Gardner's arguments was that you were locked into the kind of schemes that were being run when that provision was brought in. And again, everybody, the High Court, the Court of Appeal, just say, no, look, this is just, in a sense, this bit is straightforward, 1139. The finding the fact can be complicated and difficult, but this is just simple. And then just a final point of my notes, but I think I may have made it already in relation to 1139, was to do with, yes, I've made this. So the tax advantages can mean multiple, and just how it fits in, because obviously 441 does talk about an unallowable purpose. You sort of it talks about singular, and then clearly, I think, in my submission in little 6, tax advantages must be envisaged. And I think, or my submission on that is that the first two members of the tribunal both got it right in terms of implicit and express construction of 442, because what they're saying is you identify your tax avoidance purpose, which is the purpose of securing multiple tax advantages. And then you ask of that, which is a tax avoidance purpose, whether it's an unallowable purpose, and that's, of course, the question of name. So there's no difficulty in 441 or 442 with just operating the provisions when you're looking at multiple tax advantages. And I think that the point my learned friend made on that was he said, well, the attribution test becomes unworkable if you do have multiple tax advantages. And the kind of simple answer is that can't be right because of FIDEX and all of the other cases. But also, I think it's important to remember that the unallowable purpose is that subjective purpose test. So you're looking at all the facts to identify the subjective purpose.
But you're identifying a single unallowable purpose in any event, which is on your case.
Yes, because that's how the legislation frames the question.
Yes.
And that might be an unallowable purpose. It can be because of compendious in the legislation. The legislation has to be made to work, but the legislation does talk about this an unallowable purpose. So, and a simple way of making it fit is just to say, well, you've got a tax avoidance purpose, which is intending the multiple tax advantages.
Yes.
They're glued together by the scheme, and so on. But then I say, yes, none of that's unworkable because the attribution is the objective assessment. So you've got your unallowable purpose, and now what you're doing is attributing objectively by reference to the subjective unallowable purpose. In this case, and I'll just to sort of I'll come back to just to keep it orderly, I'll come back to Justin Easler at the end. So those were my submissions, or what I say, the points made against the revenue that can be answered in my submission by the legislation, by just giving it a proper statutory interpretation. And I hope the intention was to deal both with Speedy 1's tax advantage and the appellant's tax advantage. So I wanted then to look at the facts and show why, actually, however this case is put, and even if it were put in the simpler way that this court is suggesting, the facts have been found. And the appellant, in a sense, has got nowhere to go because the findings are made against him. I've got sort of 5 or 6, maybe a little bit more. Points on the facts. The first important point is that the group had identified the tax problem, and that was conceded from the start, and it's recorded at paragraph 48 of the decision.
So you're
Which
referring to the FTT
The
throughout
FTT.
on.
So, on the one hand, and this was Mr. Glenn Andrews, their tax manager, his own words, the group was making a lot of money. He said that in cross-examination. It's effectively in his witness statement. But on the other hand, Speedy 1 has got, when he first started looking at this in 2012, it had 48 million of trap losses. By the time they were finalising the scheme, it was 52, 53 million trap losses. So, on the one hand, a group making a lot of money. And of course, that's part of the factual background as to why the first year was entitled just to find as a fact that the appellants intended to secure tax advantages for themselves, because we're in a context where there's a lot of money being made in the Kwik-Fit group. Certainly wasn't a loss-making group.
Sorry, you say 48 covers the fact that money was being made?
No, just the fact that they'd identified a tax problem.
Okay.
I mean, the problem was how the group relief rules worked. And Mr. Andrews estimated it would take 25 years for Speedy 1 to use up the losses, the carried forward losses, if they carried on as they were. And that's paragraph 19 of the first tier decision. And he said in cross-examination and his witness statement, that was far too long to wait. And he set himself a target. This is paragraph 9 of the decision, and 97 and 110. He set himself a target to carry out the reorganisation to facilitate the use of the non-trading debits, so those trapped losses. So this is, from the start, a tax-driven endeavour. He then sought advice on two things. How to, the group had an incredibly complicated set of debt, intercompany debt. He says he sought advice on how to simplify the complex web of debt and utilise the losses. And he went to Ernst & Young, and then he went to PwC. And that's paragraph 20 of the first tier decision and 27 to 31. And the solution to the tax problem of the trapped losses was the reorganisation of some of the intercompany debt, so that Speedy One will be creditor, and of course this is critical, on that debt, and only the debt involved in the reorganisation, the interest payable would be increased from generally 0 or 0.74% to the LIBOR plus 5%. And there's a lot of to and froing with the revenue. They didn't want to pay more than market rate of interest. They didn't want to put their companies in an awkward position. But they did want to pay as much as they could, because, as we see time and time again, it was accepted that tax fed into, that the interest rate fed into the tax saving. And that comes from paragraph 60 to 61 of the first tier decision, 63 and 102 and 113. And we also know that, right at the last minute, PwC suggested to the group that they add in an extra 40 million of debt, sort of top up, speed up the utilisation of the trapped losses. And that was created by just declaring a dividend, which was satisfied by the issue of a loan note. So nothing particularly commercial about that at all. It was just, we've got so much money in this group, let's do as much as we can to use up the losses as quickly as possible.
Well, it's not money, it's just profit.
Profit.
In the profit and loss account, which is capitalised.
We've got profit. But it was the interest on the debt meant they used up.
This is the amount that was the debt.
This was conceded just before the start of the hearing. But it was conceded. It's obviously an attempt to make, in all courts, to say it's irrelevant because it was conceded. It may have been conceded, but it's clearly part of the factual matrix. And this is a scheme where, even at the last minute, they tagged on an extra 40 million of debt to secure their tax saving. So then the magic, and the court has this very clearly, the magic of the idea, or the trick, if you like, is that the reorganisation, and you can put this a number of ways, it effectively secures the surrender of carry-forward losses, which Parliament had said should not be surrendered. Mr. Ghosh said turns bad losses into good. However you put it, it's all the same thing. It's how HMRC put it in the first tier. And since I think it's said against me that points are made about how I put the case, if I could just briefly take the court to the revenues first tier skeleton argument, which is in the supplemental bundle at page 31. So just for the context, at paragraph 35, the revenues say there are these two tax advantages applying SEMA. Then at paragraph 38, over the page, the appellant's comments at their skeleton missed the point that the group implemented the planning because the NTDs were trapped. So that, and this is quoting Mr. Andrews' witness statement, the utilisation of the NTDs would take over 25 years, which from a commercial perspective was too long. The word trapped signified that the group were not permitted to surrender the carry-forward NTDs by way of group relief to other companies to set against their taxable income or gains. Yet by implementing the PwC state plan, the group effectively secured such a surrender of carry-forward NTDs to the appellants.
The point I put to Mr. Ghosh yesterday, securing by the back door what you can't get by the front.
Yes, thank you, and that's very pertinently put. The overall effect of the proposal was that they reduced their taxable income by the amount of the NTDs over 3 years. And then, actually, at 39, I was to make the point, when Parliament partially liberalised the group relief regime after 2017, they retained that restriction, so it's very much part of the group relief code.
Well, they retain restrictions. I don't think they're the same. Yeah, it's not.
Yes. So, I mean, sometimes it's argued that they changed the law and look, it must be all right. But that.
I mean, your footnoting. I think the footnote acknowledges that.
Yeah. So that's how the point was put. So and I'll take the crux of the cross-examination in a moment, the key passages to show that that was always at the forefront of what was being discussed with the witnesses. So as I say, that's also how the appellants themselves viewed the scheme. If you look at the contemporaneous documents, they're not all in the bundle. The first two obviously had all the documents, and they're not all before this court. But three that I would like to take the court to. The first is at page 136 of the supplemental bundle. I'm afraid it's rather hard to read. This is in 2012. This is the sort of genesis, the starting point.
I'm so sorry, which page was that?
Page 136.
136, thank you.
I'll have it go in. So it's an email from Mr. Andrews, the group tax manager, to Mr. Agura, the director.
So this is between the two witnesses?
Yes. I met with EY on Friday to discuss the reorganisation of the group's intercompany balances so as to utilise the brought forward losses for Speedy One. So that's their own rationale or purpose. And the rest of the email confirms that. I'm including a paper illustrating the transaction steps to achieve the desired result. The numbers may change depending upon the interest rate that's agreed with HMRC, but subject to that, Speedy One's losses would be utilised completely within 5 to 8 years. I think that was just depending on the interest rate they had in mind in 2012. I'm also attaching a draft scope of work, and then and of course this goes to the wider factual matrix, all of which the first year had before it. However, if the scheme is accepted by HMRC, the revised fee will be 150. In other words, there's a success fee for this tax scheme. And as I said, that's part of the wider factual matrix, all of which was before the first two, when we were reviewing all of the evidence. And then they make the point that that's worth it in the context of the tax saving, and of course the tax saving will be greater if the interest rate can be higher. And then the second of my three documents over the page at 137.
So, and just to pause, he's talking about saving cash tax of 1.3 million per annum for a period of 5 to 8 years. And I would suggest that can only relate to the impact of the use of the debit.
Yes.
Yes,
because as we've already discussed, Speedy One,
the tax saving. Yes.
Speedy One, absent these arrangements, is not going to pay tax anyway.
Yeah, and yes, that must be factually correct. Yeah. But the other aspect of that email is that it's part of the evidence that they intended the debits, if you like. They intended both. Well, they
I'm not disputing that, yes, but when you, I'm making a different comment, which is yes, the headline, if you like, in the email is about using Speedy One's losses, but it appears to be perfectly well understood what that is.
It's always the debit. Yeah.
It's a means to the end. Speedy One is simply the means to the end objective. The end objective is to save tax for the group. That's what that email says.
Yeah. And that is also, I suppose, what the document over the page would say. Again, it's very difficult to read, I'm afraid. Is the final half of the first paragraph. A significant advantage of simplifying the intercompany debt structure is it would permit the utilisation of Speedy One's brought forward non-trading deficits, which would amount to 51.6 million as at 2013, and thus reduce the group's total liability to tax. And then this note sets out all of the group relief rules and also how you tax non-trading loan relationship debits. Over the page at 138, utilisation of the NTDs. So now this is the solution to the tax problem of tax losses. The solution is to successfully utilising the brought forward NTDs lies in creating sufficient non-trade income in Speedy One such that intercompany interest receivable, against which the brought forward NTDs would be offset without incurring the tax liability. And then to this end, the report was sent to HMRC to agree, I think broadly, the interest rate.
Sorry, just to be clear, you're referring to the first main paragraph on page 138.
Yes, and then
on page one, just before we get there, because I lost my place, page 137, you're referring to the first paragraph, aren't you?
Yes.
Yeah, thank you.
And then over the page, it was the heading utilisation of NTD.
Yes, got it.
And maybe perhaps we should ask the appellants. I don't know if there's a. It would help the court to have a copy that can be more easily read.
Just about read it.
Well, presumably you're also going to rely on the paragraph headed tax impact.
That's correct. Thank you.
The interest-paying entities below Speedy One would obtain tax relief.
Yes. So that's a fundamental part of
and thereby reduce their respective tax liabilities, whilst the income in Speedy One be offset against the brought forward NTDs without incurring any tax liability.
And that's precisely it. So that is what is needed in order to achieve the purpose or the mischief, which is utilising the trapped losses. And then a final.
This document is the so-called June memorandum.
June
is
13
it, that
memorandum.
Referred to in the FTT decision.
Oh, right.
And then I just wanted to take the court to page 142, just one of the emails, the bottom of page 142. So this is an email from, again, Mr. Andrews, and it's actually to David Allen. I think he is Bacon McKenzie, but it's copied to Mr. Agura. So this is Mr. Andrews explaining what's happening. As discussed, we wish to restructure the existing intercompany loans in the entities below Speedy One in order to create interest income in Speedy One, which would be extinguished by its brought forward losses. Now they're 51.6 million. The rationale behind the restructure is that while the entities below Speedy One will obtain tax relief on their interest payments, the income arising with Speedy 2 will be absorbed by losses brought forward, resulting in overall tax savings for the group. And that's really the key. So the group are very, very clear. Mr. Ogura in cross-examination absolutely understood what steps were required, the rationale for the steps that were required. So then, there was just some of the cross-examination that I wanted to show the court. There's obviously a danger in, and I would accuse my learned friend of this, with his note on evidence is you can pick out little extracts and you can produce a narrative that seems to say something. In the end, as the first two did, you need to hear all of the evidence in the context of all the submissions made in the case. But I would like to take the court to some extracts just to answer some of the points made against me.
And obviously what ultimately matters is the findings of fact made by the FTT, which on the face of it are very clear and very comprehensive on this aspect of the case.
And I suppose the point I need to address is if the legal case might have been phrased slightly differently, in the sense of the focus is really on the debits. Did Mr. Ogura understand that he was giving evidence about securing the deduction? And in my submission, he very clearly did. So this is the supplemental. Oh no. At page 55 of the supplemental bundle, that's tab 5. So just at this point, I just wanted to show I'm sorry, if I just a moment. Yes, so sorry, page 55, I was on the wrong page. Internal page 68 and line 4. And the only point of this passage is to show that it was part of a different conversation, but that I did put to him, this was a number of times, and this is one of them, what HMRC's thesis was, if you like, which of course we got from the June memorandum. The question is, are we at cross purposes? Maybe. So I'm not talking about the timing of the decision made by the board. I'm talking about the nature of why the reorganisation delivered a benefit to the group in terms of using trapped losses. So that's all I'm talking about. And the benefit to the group was that by creating net interest income in substantial amounts in Speedy 1 through the reorganisation, and Mr. Ogura says yes, those trapped losses would be used up in a period of 2 years, 2.5 years. Whereas if you haven't done the reorganisation, the advice from Ernst & Young was it might take 25 years. So that's what I mean by accelerating use of trapped losses. So that's part of it. But then we go on and we agree what we mean by using the trapped losses. And perhaps if I go to page 78. Yes, so I'm told that's internal page 78, which is page 58 of the bundle, internal page 78, line 18. So what I've done here is put to Mr. Ogura the 2012 email from Mr. Andrews.
Is that one we saw earlier?
Yes, that's
Thank you.
And so we read the email. And then at line 18, page 79, so you'd agree from the very start that paying more interest directly fed into the tax saving, the tax benefit. Yes, I agree. In a sense, it's obvious, because the point of the reorganisation is to put net interest income in Speedy 1 hands, because if it has more net interest income, it can use the trapped losses against that. And then, of course, the debtor company that's paying the interest, it gets the tax deduction. And that's the idea, isn't it? That's the sense in which you're accessing the losses. So then whenever in all the the evidence in the cross-examination, we're talking about accessing the losses.
So, to be absolutely clear, this is Mr. Aguro,
Yes,
isn't Mr.
the director of
being
all the
cross-examined.
appellant companies.
I'm so sorry, I seem to be on the wrong page. Is this main page 58, internal 78?
Internal, so, well, sorry, I was a little unclear. Internal 78 begins where I put the email to him, but I read from page 79 internal.
Oh, I see.
Line 18.
Oh, sorry, it was 70.
Because prior to that, I was just reading out the email.
Thank you. Sorry, I wasn't there. Yeah, thank you.
So we agreed, Mr. Gore and I, what it meant to utilise trapped losses. So insofar as an extract in my learned friend's note makes it look like I'm only talking about utilising losses in Speedy 1, the whole context was Mr. Agora understood utilising trapped losses means you need to secure the deduction in the appellants. You need to have income against which can absorb the losses in Speedy 1. And then just at the bottom of that page, so it's internal page 80. So then this is simply where I put the other email that I took you to, and I put that to Mr. Agura. That's the rationale email. And what I say at the end, so we've looked at that email, and just at page 81, internal line 21, that first paragraph, that confirms what we've just agreed, doesn't it? Which is the nature of the proposal to use the losses. Yes, and that was that email setting out the rationale. So the twin elements. And so what I say is that's the essence of what the first two are finding at paragraphs 97 to 104 of their decision, and especially at paragraphs 110 and 112 to 13. But it runs through all of their findings. Mr. Gore absolutely understood what we were all talking about when we talked about accessing trapped losses. It was getting the deduction in the appellants. It was absorbing the losses in the... And so it really can't be said that I didn't put the importance, if you like, of the deduction in the appellants to Mr. Agora. Obviously, I don't have to ask him, was it your main purpose within the meaning of sections? And I didn't do that, but I did interrogate him on what he understood about what he had done as director of the company. So that was my point for the magic of the scheme, put to the witnesses and well understood by the first tier. The next point I wanted to make is that there is plenty of evidence that the group wanted the debtors to be on board and willing participants, and that's the first tier's findings at 63, little 4, and 102, the end of 101, and especially 101.5.
Sorry, can you give those references?
So sorry, at 63, little 4, and paragraph 100 to 101. They were willing. It wasn't just that the group wanted them to be willing, they were. I mean, yesterday, Majesty, you sort of asked, well, how is it that the debtors are being asked to approve and consent to the change of the creditor? And obviously they had to agree to the change of interest. And one of the reasons, one of the arguments put below in the first tier very strongly was, in effect, that the appellants were all just very passive. You know, they didn't need to consent to the change of creditor. Paying a market rate of interest wasn't something that needed thinking about. But the passive nature of being a debtor and having your creditor changed was something that was focused on. So in the cross-examination, you see me going through a series of the documents showing why they weren't in fact passive, and moreover, the group as a whole wanted the debtor companies to be on board. And so, moreover, I mean, they were often taking steps to actually help the change of creditor. So there's no part of this where they were just sort of passively being, sort of party to something that they didn't have any intention about. That was not the fact.
I mean, if you contrast it with the situation where the benefit of the debts is assigned by the creditor without necessarily the debtor's knowledge, I mean, that would be a different. That would be the other end of the spectrum. But here, they are on any view, they had to be active participants because they had to agree the higher rate of interest, and in many cases as well the other steps like paying and receiving dividends and so forth.
And as the tribunal find at paragraph 63, I think it is, that at one point one of the companies was both creditor and debtor, and it nevertheless agreed to dividend up the right to be repaid. So it was very active in the whole process.
I'm also a kind of mastermind who prepared a schedule setting out what everything had to do with a timetable or tax.
Well,
like that.
there is a PwC step plan, I think it's called, in the first tier. And there's a late version of it in the supplemental bundle. There were more. The revenue saw an early version. They didn't see the final. But yes, there is a very...
I mean, as one would expect. Presumably.
You can see, and I mean, if the tribunal, if it became relevant, in an appendix to the revenue skeleton in the first tier, we did produce a table where for each debt, we just describe what had to happen for the change in creditor and the increase in interest rate.
I think there's some very detailed findings by the FTT.
And in the FTT. So, but none of that's in dispute. But if for some reason you wanted just a bit more background, that's how it works. But otherwise, I don't think the court needs to know the detail. And just a few passages that make that very clear. And I say this because it's obviously one of the ways the case is put, is that there was a muddle between knowledge and purpose, and then also sort of this group purpose. But there was no difficulty in the evidence. So page 51, again, Mr. Agura's cross-examination. So it's the bundle, page 51. And as it happens, it's internal, page 51. And at line 6, Mr. Agura says, yes, GB has consented to the higher interest rate as part of reorganisation. And then I say yes, and more generally, GB's approval and cooperation was required because it had to perform step 2 and also had to make a distribution at step 4 of the 9.1 million loan note. So the group would want to know it was on board, it was a willing participator. Mr. Agura says yes. And also, and then I put something to him that was conceded, and he says, is that correct? And I say yes. And he says, and I say one part of that process was the debtor would pay more interest and it would get a corporation tax deduction for the interest that it was paying. You understand that? And he says, yes, I understand that. And so, of course, if there was a challenge, it would be the appellant who'd been in court, as they are today, defending their position. So it was important they were willing participators in the reorganisation. And the answer is important in the first tier, make findings on the basis of this. Yes, because the reorganisation was a decision as a whole. And I think by company that means the group. And Kwik-Fit GB also part of the whole group. And the decision was made as a whole group. And GB was part of it. So they also understood and cooperated in the decision made as a whole group. So a lot was made in the first tier about, they'd obviously conceded that the reorganisation had a purpose of utilising losses. And then there was a distinction was sought to be made between the reorganisation and then the actual being party to a loan relationship, but also group purpose. And what the first tier rightly find is that no such distinctions can be made. This was a very collaborative, cooperative endeavour by appellant companies who were well on board with why they were being asked to do something.
So just to be clear, the case was being run by the appellants in the first tier on the basis that, if you like, these appellants weren't really party to the group purpose.
Yes, and that we had to prove that yes, I think that's fair. I mean, having made the concession that the reorganisation had a particular purpose, they then had to explain why they hadn't conceded the whole case. And of course, in a sense, what I was doing with cross-examination was showing actually in the end, given the nature of the way this group operated, you did concede the case. But I mean, it's not put like that, and I don't need to. But it was an important concession in the factual reality. And then at the bottom of page 52, again, I say yes, the choice. This is line 22. The choice for GB was just to participate or not. And if GB had a good reason not to participate, then it would have been left out of the organisation. And he said that could be possible. But as I mentioned, it was a decision of the whole group. So in a sense, GB wasn't going to opt out because it could see the tax saving or the benefit of being party to the organisation. But there was no doubt in the first year found that there were no threats. No one was under threat of having their loans withdrawn if they didn't agree. This was a willing and positive decision. And that comes across very clearly at internal. So it's the bundle, page 56. Internal, page 71. And this is in relation to what was termed the pushdowns. There was actually two new debts, but they enabled another larger debt to be repaid. But they were, no doubt, in the end, two new debts. And I say now both of these debts, this is line 17, page 71, both of these debts you agreed before the pause were new debts incurred for the first time by finance and staple firms. We agreed that, yes. And I was looking at the reason why the board of those two companies, and indeed the member shareholders, would have wanted to procure the dividend to be satisfied by the new loan note. And my question to you is, the reason is to assist in the groups, the reorganisation. You agreed that the reason why the two debtors agreed to incur new debt, and why, and Mr. Agora says yes, their shareholders would have asked for the dividend to be paid by the issue of a new debt, was to assist the reorganisation. He says yes, part of the reorganisation. And then I say both companies understood the interest would be at 5% LIBOR. Yes, but because that was part of the reorganisation, that's right. And the reason why they were willing to do that is they understood there'd be a benefit to the group, which would be utilising these trap losses in Speedy 1. Yes, that's right. So if the revenue put the case in the alternative and said, well, the unallowable purpose is intending to secure the deduction on the debits, and what made that a main purpose or an unallowable purpose was the twinning with the interest absorbing the losses. There is, in my submission, clear evidence that deduction was at the forefront of the directors' minds. I mean, that was their purpose. The reason why they were willing, there is evidence, which is the first year's findings, in effect, that they were willing to enter into the new debt. In other words, which would mean secure the deduction in the context of this reorganisation, which we've discussed earlier in the cross-examination, is to secure the mischief, if you like. So you don't have to put, if it mattered, you don't have to put the case in terms of intending to secure the tax advantage in Speedy 1, because there's evidence for the case being put in both ways. And my submission kind of inevitably so, given the nature of the scheme. And what's really happening is that after the event, is a matter of legal analysis, you're working out how it fits into the statutory terms. I just had a few more passages to take the court to. And this is at page 73. Page 57 of the bundle, internal page 73, line 5, we've been talking about the reorganisation, the rationale, of course, which was to secure the trap losses. That's the appellant's own evidence. That's right. And so I take him to some documentation drafted by Baker McKenzie, and we see that all the debits all consent and approve the assignments. They all consent and approve the change in creditor, and he agrees. And again, I make the point, this would accord with your understanding, the reasons for why their consent would be important, similar to those discussed at the start. The group would want those debtor companies to be willing participants in the reorganisation, and the reorganisation has as its rationale securing those twin benefits in order to secure the tax relief. Yes, and those debtor companies gave their consent knowing the benefit to the group of the identity of the creditor being changed. And Mr. Agura says, yes, that's true. And I say, and I put it like this, they could see that there was a good use that the debts they owed would be put to by the group. Because, of course, in the end, we're coming back to, what was your purpose? Did you have a new purpose for being party to the loan relationship? Mr. Agura says, yes, we had a new, I could see that the loans were being put to a new use for the benefit of the group. And it was clear that the benefit of the group was that tax saving. So I understood that our reorganisation was good for the whole group, and the debtor company also confirmed there was no adverse commercial consequences from the change of creditors. And so I said, so there was no downside, and he said, yes, but there was an upside, and he says, yes, and they wanted the upside, and he says, yes. Because the upside was accessing the trap losses, which, as I said, is compendious, it's the two things. Mr. Agura confirmed, I think, again, that paying interest fed directly into the tax saving. There is some cross-examination about the revenues, getting the revenues agreement to the rate of interest and two aspects of the scheme. The reason why there's cross-examination on all of that, and there are findings at the end of the first tier decision, is because it was it was part of the case, sort of quasi-unfairness, judicial, hand in hand with relying on the revenue manual, saying this sort of thing ought to be all right, and look, the revenue thought it was all right. Inevitably, when you look at all the detail, it's not quite that simple, and the first tier dealt with it, put it to one side. But in the course of that, there's no doubt that they wanted the revenue to agree that LIBOR plus 5% wasn't in excess of a commercial rate of interest. There was no dispute that they didn't want to do this scheme by paying more than a commercial amount of interest. That was not an issue. But in my submission, it doesn't answer any of the issues in this case. I realise actually saying that there's perhaps one aspect of 1139 I forgot to mention, which is whatever view you take of the scope of 1139, there is absolutely nothing in the words that would suggest that whether or not you're paying an arm's length rate of interest would take you in or out of 1139. You really can't find that in the words of the sanction. So,
well, on the topic of the arm's length rate of interest, were you actually going to take us to your cross-examination of Mr. Andrews on page 72? Internal pages 31 and 32. I am particularly interested in the answer he gave. No, it wasn't the deal.
I'm sorry, I've got a page 72.
Yeah.
Is it line page?
Internal pages 31 and 32. Your question at line 19,
yeah.
It wasn't the case that they were told we're going to demand repayment unless you pay this interest rate. That wasn't the deal. He says that no, it wasn't the deal. At the end of the day, the debtor companies knew that to a large extent they could not afford to repay, nor could they go up to the market and get a better rate. So therefore they entered into the reorganisation because at the end of the day, the debtor companies, being part of the overall group, would benefit from the benefit to the group of the reorganisation, and that was the driving force. Your question, they would benefit And the PwC idea, because they would get the CT deduction, and Speedy One, the group, would be utilising the trapped losses, and so the benefit accrued to the whole group. Answer correct.
Yes, thank you very much. So, right.
That's putting it about as squarely as you could possibly have put it, isn't it?
And I think I also had, yes, well, that's it. Thank you very much.
Proves that some of us read ahead, you see.
Yes, so I'm moving on very quickly with the facts. There's, I think, just 2 or 3 more points, and then I can move on just to the law really on main purpose and Seymour and Claimant Benson as far as relevant. The other point I wanted to make was that it is important that not all the intercompany debt was involved, because that evidences the deliberate nature of what's going on. And this detail agent loan, it's relevant evidence because it shows that it feeds really into the transfer pricing also. This was not, the driver of this reorganisation was not to fund Speedy One to be an incredibly valuable company. We've seen there's plenty of evidence that the rationale of the reorganisation and paying the extra interest was to secure the tax saving. And the detail agent debt is just part of the factual matrix, which shows that that was a finding the tribunal were entitled to make, because it was a debt that, had they applied the 5% rate to, would have, as Mr. Ghosh conceded or admitted, slowed down the rate of utilisation, because it would have, the mandatory rules would have kicked in and they'd have had to have set off their brand new interest against the brand new debits, achieving absolutely nothing. It's relevant, it's part of the factual matrix. In a sense, it's a bit like paying the success fee to Ernst & Young, or that all of this is relevant, all of this goes into the first year's findings. And then, just to look briefly at what might have been the other purposes for the reorganisation. The first did find that a group purpose was to simplify the amount and the quantum of the debt and the number of debts in existence. And the findings are at paragraph 63, little 1. The appellant's submission is at paragraph 80, and there are further findings at 101, little 3. And what they find is the simplification did not go so far as it could. There's certainly no, and there's one, I think I put, I was cross-examining Mr. Agora, and I said, so I think maybe we should just look at it simpler, but at page 80, internal page 87, I'll find it. Bundle page 60, and it's internal page 87, just line 20. So I say, so the simplification was a benefit, and insofar as there was simplification, it was a benefit which was sort of incidental to the restructuring, to use the losses. And he says, well, there were 2 purposes, and one was simplification, and the other was using the deficit. But the tribunal, they heard all that, and they heard all the evidence, and they make their findings, and those are findings perfectly open to them to make. It was not the driver, and it was not the sole driver. So, they called it background noise. Simplification in terms of reducing the number of companies. Maybe that's a slightly different point. The number of dormant companies they call background noise.
Where's the reference to background noise?
I think it's, is that 63 or 1? paragraph 104.
Yes. Last sentence.
But there is no finding of fact that there was a positive purpose of funding Speedy 1 in any relevant way. And my learned friend has picked up on I think it's really a submission made by Ms. Shaw below at paragraph 80. Ms. Shaw submitted the reorganisation was ordinary corporate housekeeping, the purposes of which was to simplify the group balances. Well, the first two made its findings on that. Establishing Speedy 1 as the group treasury company. And that's what's said. The tribunal don't make any findings because there wasn't anything before it on which it could have made the findings. Of course, what you're not allowed to do is infer from the fact that the tax scheme required interest to be paid, that there must have been a main purpose of putting the interest in Speedy 1. There needs to be some evidence of that. And what we've got really is, we've got that submission, and all you can take from that, and I think from the evidence, is that Speedy 1 was going to be that Speedy 1, it made sense. If you're going to do the reorganisation for the losses, then Speedy 1 will end up being the treasury company. So part and parcel of simplifying the debts would be to have one creditor. But you can't. Mr. Ghosh wants to take that when we come to attribution and say there was this main purpose of making Speedy 1 a treasury company, and because of that, this interest would always have arisen to Speedy 1. So, but for, and so on and so on. And I'll come back to the attribution. But just looking at the findings of fact, the findings of fact aren't there to assist Mr. Ghosh in making that argument. Even if it were one that was, open in the sort of appellate courts, it wasn't, you need to make that good in the first tier on the facts, and the appellants didn't. What we do know is all the evidence on what the driver was. And I think really just to understand the context, partly going to the sort of lack of evidence on this, is if you just consider what the appellant's case was in the first tier on the evidence, and that's the non-tax avoidance purpose, if you like, and that's set out in the witness statements of Mr. Andrews and Mr. Agora. And they are in the supplemental bundle. Mr. Agora's witness statement is that supplemental bundle starts at tab 3 and at page 7 he's got a paragraph for the appellant.
Sorry, tab 3.
So sorry, it's a supplemental bundle.
Tab
1, and the bit I'm referring to is at page 7. And they don't say, Mr. Agora doesn't say, they had this amazing idea of funding Speedy 1 so it could do all of these things and operate in this way. And then we realised that if we did that, then we might get this incidental benefit, for example. That's not the case. That was not the evidence. Mr. Andrews similarly. Page 17 of the bundle, paragraph 5.9 to 5.14. And he very much focuses on the appellants and their reasons for being party to the loan relationship. And as far as interest, paying more interest is mentioned, it's all in the context of, oh, well, the revenue have agreed the rates. That's why it's not called. There aren't the facts to support that submission, and it's too, well, there aren't the facts, so I don't think it can be made, even if it could be made in this court, it can't. So what I wanted to do with that was answer, I hope, the sort of factual points, the points made against me in relation to how I put the case to the witnesses. And in light of the questions from the court is, well, if you viewed the legal test or the approach in a different way, is there evidence to support that alternative approach? And the answer to that is yes. Although our case is obviously that there are two tax advantages were intended. What I wanted to move on to do is look at, well, extremely briefly make a comment on the law on the meaning of a main purpose. It's, I think, pretty much settled, if you like, for the purpose of this case. And then deal with, just make some points on knowledge and purpose. And then Seymour and Final Benson. And that is probably, apart from transfer pricing, which is a sort of short point, that's my case on the first part, issue 1. And then it's just the attribution question. So the revenue, the first tier set out the test that it was applying on assessing whether there was a main purpose at paragraphs 54 to 57 and 78 to 79. Now, obviously, they were deciding this before the Court of Appeal in Blackrock and before some of the other upper tribunal decisions. But you can't identify any error of law in how they set out the test, and in my submission that's nor in how they applied or understood it. There are references to Brebner, Travel Document Service. And an important point just to highlight is paragraph 85 of the first tier decision. Where they say we must be mindful that we have to look at the purposes of the relevant company. So they were not, seduced into looking at some sort of group purpose. Because, of course, there were 4 appellants in a group scheme, to an extent, all arguments in the case was put in terms of the appellants. But they were dealt with case by case where it mattered. And the tribunal is very clear as to what the test is and what the test they are required to consider. At paragraphs 90 to 93, the first tier addressed the possibility of change of use and when evidence of use is evidence of purpose. And what they say is it is absolutely correct. It's the cases of FedEx and Travel Document Service. As I say, they didn't have the benefit of the Court of Appeal judgment in Blackrock, but much of, I suppose, the difficult and interesting debate in Blackrock about Vodafone and Malley and Drummond isn't really an issue in this case, and Blackrock confirms what the first tier understood, which is objective test. You look at all the evidence, but you come back to what did the decision makers of the particular company intend. And BlackRock, I think, confirms that. BlackRock is also very interesting when we come to the appellant's argument on the confusion of knowledge and purpose, because I think that is very helpful in my submission to this case. And it's at paragraph 161 to 162 and paragraph 192. And the point made is that you are really asking, or one way of interrogating a company's purpose is to ask why you are doing it. And Lord Justice Nugent expands that to say, knowledge is different to purpose. But particularly in a case like this, knowledge can be very good evidence of what your purpose was. If you're a willing participant in a well-advised scheme by PwC, and you're giving your informed consent, knowledge is very good evidence of your purpose. The first two understood that. That's absolutely clear from the entire decision. And so I rely on BlackRock for that very helpful statement. And I should say the remedy have always accepted in this case that knowledge is different to purpose. But the question is, what did you actually intend?
And we didn't have any complications in this case, do we, about the sort of objective add-on, which is the inevitable consequences of the Malibu or the
No, I don't understand that to have been raised against
so really,
and the revenue aren't making anything of that.
No.
I think the evidence in my submission is very clear, and it's just they intended what they said they intended. And it's not a case where they were told not to consider something. It was all done in a very kind of open way, if you like.
And what do you say about the point that the link between knowledge and purpose wasn't explicitly spelled out by the FTC? And I think various stages, Mr. Ghosh seemed to complain about there being a sort of a gap in the reasoning, or the jump from setting out the findings of knowledge to the conclusion of purpose.
I think that the jump is an imagined one, because this, if you read the judgment as a whole, I'm sure the court now has read it a number of times, there is no gap, because this is a case where findings about what you know is a way to find out what they intended. And of course, you can't bar the tribunal from talking about what they knew when they knew it, and what they're doing, and why they're doing what they're doing is because they knew that this would be the outcome, and that's what they wanted. So I think the gap is imagined.
Well, I think you effectively say it just one follows from the others.
Yeah.
If you know, and you both know about it, and it's not an unwelcome thing.
And you set about to do it deliberately.
Yeah, in a sense, it almost seems too obvious for words.
It's too obvious for words. I will adopt that submission. Yes.
Well, it's not really.
As a submission, I mean. But,
yes, I mean, maybe you say it in those circumstances, it would at least be open to the fact finder to find those opponents.
Absolutely, and that's all I have to show. And in my submission, really much of what Mr. Ghosh says about the facts of this case is just a sort of disguised Edwards and Bairstow, and they're nowhere near meeting the
Paragraph 101, I mean, inferences are being drawn from the primary documentation. We find, based on the evidence of Mr. Igura, which you've taken us to, that the 2013 June memorandum sets out what the directors of each company wanted to achieve. That's not just their knowledge, that's what they actively wanted to achieve as is set out in contemporaneous documents.
Yes, and then the documents all then show that continues.
Yeah. The outcome was considered to be good for the whole group. There was a group purpose. I suppose that's what it was.
And so then in relation to the upper tribunal, in my submission they were perfectly correct to find that there was no error of law made by the first two. I was going to return to the Seymour Claimant Benson. I think I wanted to deal with the proposition of my learned friend. It's slightly evolved, I think, yesterday from the point made in the skeleton. But I think the point is that Seymour endorses a proposition that traders and borrowers can't have a tax avoidance purpose in certain circumstances. And this isn't an argument. Well, I suppose it might be an argument about tax advantage. But it's also very much an argument about purpose, I think, because that's how it was considered in Seymour. And the point that I would make is that actually, considering the difference in outcome in Seymour and Claimant Benson, what Seymour actually shows is that there aren't any givens when you come to purpose. Just highly fact sensitive. And in particular, Seymour does show that there's no rule that intending a provision to do what Parliament intended of it is of itself somehow safe from the unallowable purpose rule. Because in Seymour, that's exactly what happened. But the problem in Seymour was that wanting a provision to apply was crucial to his decision to sell back the shares. So it wasn't a problem with there was no distortion of the exemption or the rule. He was doing exactly what Parliament had said he had to do to secure the benefit of the rule. He sold back his shares. He was exempt. He's a trustee. An exempt trustee. By being an exempt trustee of the pension fund and selling back the shares, he gets the trust gets the tax treatment. It's an indivisible single transaction. It's incredibly simple. But because the only reason he sold on that date at that time was to get the exemption, the special commissioners found that his main purpose in selling the shares was our main purpose in selling the shares back to Powergen was to secure the exemption. And of course, you can understand why that's the case, because he was selling back at a commercial loss, but because of the exemption gave him the right to claim a tax credit, then he's commercially better off.
Yes, it is quite a stark case, because they
stark
were
case.
planning to sell anyway.
It's a stark case because he was selling back at a commercial loss, and the only reason he was doing it was to get the tax credit turned his loss into a profit. So did I say? I'm not sure what I said just then. He bought at a higher price than the company was buying back.
But I think the evidence was there was a plan. They wanted to offload these shares anyway, but the decision was that
to sell today.
This particular transaction was one that was driven by tax.
Yeah. And you can see that seems rather harsh, but certainly what it is an example of the provision doing exactly what Parliament intended it to do. So that is not a test. The reason Seymour lost is because of the facts. All the facts found by the fact-finding body. And then equally, in Claimant Benson is interesting because it's equally fact-sensitive. And we always jump straight to the decision, the obiter comments of Mr. Justice Cross. But in Claimant Benson, equally, they only made a commercial profit because of the tax treatment. But there, on the particular facts of that case, held no, not a main object of securing the tax advantage. And it's just all fact specific. And my point really is one shouldn't approach 442 or 1139 as if there's some category that is necessarily outside the rule. Now, as a matter of reality, everybody does that because there are some things that we happen to know that on analysis would be fine. But that doesn't mean that, as a matter of law, there is some transaction like selling shares back as a pension trustee to the company that is automatically outside the scope. That's a wrong approach to the legislation. And that is the importance of, it's the passages at paragraph 52 and 53 of Mr. Justice Lightman in the High Court in SEMA that my learned friend asked the court to read yesterday, I think, perhaps over a short adjournment. He is saying it is a fact-sensitive issue and it's for the first tier. Just because Claimant Benson won doesn't mean that the trustee in SEMA wins. And I think that really feeds back, just in the context of this morning, it feeds back into section 1139 and my point, which is it is in my submission important to remember that when you ask about whether you've got an intention to secure a tax advantage, you can secure that tax advantage in a number of different ways. And one of them could be to put income in a company that you otherwise weren't going to put any income in because it has this advantage to you, this overriding benefit. My final point on purpose is that the transfer pricing rules are completely irrelevant to purpose. On the facts found in this case, well, the first tier find or give their decision on this aspect at paragraph 114, and it can't be faulted. I mean, what they find is that there was no evidence of an intention to apply the transfer pricing rules. They simply weren't able to make that finding. They haven't been given any evidence. It
wasn't the case that the appellants want to put anyway. Mr. Ghosh told us very frankly that it was not his client's case that the interest hike was in any way motivated by an intention to comply with the transfer pricing rules. His point was a slightly more sophisticated one.
But nor could that be a given, if you like, or a rule, which is so long as you're paying an arm's length market rate of interest that you would be equal to the rate you would have paid had you applied transfer pricing, which you didn't and didn't want to, then you're outside the underlying purpose rule. And I say there's no such rule. And the purpose is about the subjective intentions. You look at those and the tribunal makes changes.
The fact that an arm's length rate of interest is being paid may be part and parcel of the overall evaluation to determine whether the purpose is to secure a tax advantage or to restructure the company in a manner which is commercially viable and complies. Just because you want to comply with the Inland Revenue rules in certain respects doesn't necessarily mean that you're not trying to get a tax advantage.
And that's absolutely right. And obviously, I mean, I imagine almost every other case in the bundle is an example of that. Oxford Instruments, I think they were paying. They took care to pay an arm's length rate. Because what you don't want is your tax scheme to be scuppered because you've got the interest rate so high that it's all disallowed under a different avoidance provision. But it doesn't show more than
And the acid test here is the fact that the loans, like the detail agent one, was anyway excluded. I mean, that really makes no sense at all on the footing that there was an intention to belatedly comply with transfer pricing regulations.
And it's why the first tier's approach on the just and reasonable attribution is completely correct, for really those very reasons, which is that purpose in relation to transfer pricing didn't exist. So why would you assume the benefit of it when in fact you acted to the contrary, when you're attributing to in relation to an unallowable purpose? So those were my submissions on the issue 1, so in relation to the purpose aspect of the test. I was just going to move on to the attribution, and then that was also case 9.
Will you comment on the capping point in that context?
Yeah.
I think it's helpful to do so.
Here again, obviously, the law has moved on since the date of the first tier decision, but the first tier nonetheless apply the law as it has evolved or been, as most recently stated in any event, in BlackRock. And their findings, or they set out the test it begins at paragraph 118 of the decision. And then at 119 you see the appellants were arguing, well, because they would have been the same had they applied the transfer pricing rules, you should have attribution. And that's not a right approach. And then the revenue make their submissions. And then the first tier set out or consider FIDEX and travel document service and Oxford Instruments. And what they say at paragraph 128 is interesting. I mean, Judge Beer in Oxford Instruments sought to formulate a test that might be used. And the first tier don't adopt that test. At 128 they say, actually his test illustrates the difficulty with seeking to formulate a principle which can be applied to a different fact patterns, as Judge Beer's layered various factual preconditions into a but-for test. And then at 129, we are wary of seeking to rewrite a test which is set out in the legislation. And I think that does come out of BlackRock, which is, it's not a prescriptive test, I think, the words used. And instead we should focus on the requirements therein to determine the amount of the debits which should be attributed to the unallowable purpose. Noting that 4.4(3) already directs us to make such determination by a just and reasonable apportionment. We nevertheless recognise that asking the but-for questions of both the existence of the loans and the interest may be of assistance in testing the apportionment. And again, my submission completely consistent with the decision, the judgment of this court in BlackRock. And then they set out the approach taken by the revenue. And then they make their findings at 132 through to 138, and 138 ends with the cap. What I thought, just for sort of clarity, if you like, I thought it might be helpful for the court to see how the revenue set out their view of the test. Because again, in my submission, the revenue's attribution, which was adopted all bar a small amount by the tribunal, is the one that they adopt. And the revenues approach is consistent, in my view, with what the guidance given by BlackRock. And that is it's the revenue skeleton, paragraph 51. So it's supplemental bundle, page 35. Page 35, paragraph 51. So the revenue disallowed more of the debits than the first tier did, because the first tier allowed the debits on the pre-existing loans to the extent there was any interest. The revenue had disallowed that. But subject to that, and of course the revenue capped it, and the appellants were not challenging the cap, obviously, in the first tier as far as applied. So paragraph 51, this approach meets the statutory test. It respects the original commercial purpose of any pre-existing borrowing and the unallowable purpose. So this is the pre-existing loans. By disallowing interest insofar as attributable to the desire to access trapped NTDs. So that's the unallowable purpose. Essentially, the debits are disallowed only to the extent of the carried forward losses which were trapped under the ordinary application of the group relief rules, which were accessed in the 3 years under appeal as a result of the scheme, with each debtor actively playing the role allotted to it in facilitating Speedy One and the group's access to the excess NTDs. So it hasn't been expressed as a but-for test, but what the revenue are doing is identifying, if you like, the mischief, I suppose you could put it, and saying, on the particular facts of this scheme, how much of the debits are attributable to the mischief? Now, the revenue said that's all of the debits, because actually they all agreed to play their role in changing the creditor. So even in the case of an existing debt, you have a new purpose in respect of even the existing interest, if you like. So your purpose in holding the loan note infects the whole of the interest. And that aspect of it, the first two didn't accept. They, on that basis, they said, well, the pre-existing interest, even but for the scheme, and they recognised this was a but-for test, would still exist.
You've got a respondent's notice which I think says if we were minded to interfere with the apportionment, you'd want to have another pop at that existing interest. Is that pursued?
I think we were covering our backs in case the Court of Appeal came up with something really very different, and everything was that we were in a different world than where we thought. If in the way the case has gone, we're not positively seeking a different. We're not challenging the first tier's attribution, and we accept it. It was only if something had happened which meant that we were fixed with something that suddenly made no sense, and it meant that we couldn't argue for anything else. So no, sort of procedural covering our backs.
And I think just going back to capping as well, it's sort of I think it's implicit in the way that you've shown us from the way the case was argued in the FTT, that the capping, to use that shorthand term, is an aspect of the just and reasonable apportionment. It's an aspect of restricting the debits insofar as they are properly attributable to the mischief.
Yes, and looking at the case in the way the revenue have put it all along, if there's a twin intended tax advantage, they are only a main unallowable purpose, because while you've got the two of them, it's or put it the other way, it's only while the intention in relation to accessing the trapped losses, which is the Speedy One, exists, that the intention in relation to the debits has this quality of being, the be-all and end-all of what you're trying to do.
Well, the figures counterbalance each other, don't they?
Yeah.
I mean, it's another illustration of the fact you simply can't look at one aspect of the scheme without the other.
Yeah.
I mean, they're interlocked, and once the losses have been used up, well, then revenue got nothing really left to grumble about.
That's right, and it's the fact that the just and reasonable attribution can work like that and does and actually the first tier made a slight adjustment, but otherwise approved it. It is a strength of the just and reasonable approach. It's not showing that there's some terrible problem with having found, in the way the first tier did, that there's an unallowable purpose, for example. You know, Mr. Ghosh said the point, the way the revenue had put the case, or the first tier found the case, made the just and reasonable test unworkable. It's simply not. It's not the case. And it's only unworkable if you fashion up a meaning of the just and reasonable attribution test, which makes it unworkable. Well, you can do that, but it's wrong as a matter of law, because as this court has confirmed in BlackRock, it's not prescriptive. There is more than one way of applying it, so long as you meet the words of the, 4413, I think it is. I may have one or two short points to make, but I think it would help if I could stop now, and then I can just check that I haven't got anything.
Well, we seem to be doing quite well, I think, in terms of timing. So, shall we say 2 o'clock?